This two-part series was inspired by the release of two extraordinarily timely and important books this year, 2024. Lawyer Nation, The Past, Present, and Future of the American Legal Profession by Professor Ray Brescia, and Law Democratized, A Blueprint for Solving the Justice Crisis by Professor Renee Knake Jefferson. I am going to put links to both books in the chat. I highly recommend them. They are excellent. They're both in very different ways, urgent appeals to lawyers, to judges, to academics, and the public that we need to rethink our approach to lawyering and the legal system to meet some of the most daunting challenges that we have right now. Challenges to access to justice, the legal profession, and our democracy. And really more daunting than our country has encountered in many decades. The authors of these two books are excellent emissaries to make those appeals and to bring our attention to those issues. Renee Knake Jefferson is currently the Doherty Chair in Legal Ethics at the University of Houston Law Center. And Ray Brescia is currently the Associate Dean for Research and Intellectual Life and the Honorable Harold R. Tyler Chair in Law Technology at Albany Law School. But their accomplishments and contributions go far beyond those titles. They are too many to detail here, but it is more than fair to say that they both have devoted extensive attention in their exceptional academic practice and public service careers to the issues being discussed, beyond even the publication of those books. We are really thrilled to have them here. Both today and at the second session of this two-part series on April 10th, we're fortunate that they're going to be providing opening remarks to start the discussion. Today in part one, we're going to be looking at the state of the access to justice crisis in the United States and positing a way forward. The panel is going to focus on ongoing challenges to diversity, equity, and inclusion efforts, the risks and opportunities of developing technologies, and the potential of opening the legal profession to non-lawyers. Or as my colleague Ellen Yarashevsky put it to me today, DEI, AI, and UPL, just to put it all in initials. I hope I didn't steal your line, Ellen. On April 10th, in part two of this series, we're going to be focusing on democracy and insurrection, and we'll be looking at arguably the most imminent and existential crisis confronted by the legal profession in our country, the moral and ethical duties of lawyers when democracy is under attack. Besides hearing from both Professor Brescia and Professor Knake Jefferson today, we're going to hear from an amazing panel of speakers. And we're also going to be reserving time for questions from the audience. You should put any questions you have in the chat, and we will get to as many as we can. The moderator for today's program is my beloved colleague, Ellen Yarashevsky. Among the many, many hats she wears in the fields of ethics and social justice, she is the Howard Lichtenstein Professor of Legal Ethics here at Hofstra, and the recently appointed co-chair of the newly formed ABA Prosecutorial Independence Task Force of the Criminal Justice Section at the ABA. I'm going to turn it over to Professor Yarashevsky now to introduce our speakers and get the conversation started. So to you, Ellen.
Great. Thanks so much, Teo. I'm really thrilled to be the moderator for this wonderful program. Both of these books are terrific. So in advance, I want to thank Ray and Renee for writing these remarkable books. In addition to them, we are really grateful to have three amazing people as part of tonight's discussion. They're highly experienced, thoughtful people. I'll introduce them more formally in a minute, but we have leaders in the profession who have been deans, they are professors, leaders of the ABA, international organizations, and organizations about the future of the profession. So if there's students here who are interested in leadership, careers in the profession, you couldn't have a better panel than tonight's group. I suggest that you look at their Wikipedia entries. Everyone has a remarkable Wikipedia entry. So let me start with our panelists. So Deborah Enix-Ross is currently at Debevoise in Plimpton. She is the Senior Advisor for Global Engagement in International Dispute Resolution. She's a member of the firm's Diversity and Inclusion Advisory Council. She has a long history in international work. Prior to the time she joined her firm, she was a senior legal officer and head of the External Relations and Information section of the World International Property Organization. And there are many other organizations with a lot of acronyms that Deborah led and was part of. Most recently, she's the past president of the American Bar Association, which of course you know is the largest American bar association with several 100,000 members, where she did significant work on DEI. She participated in the ABA for a long period of time. And the last thing I'll say about her, and I really do suggest you read everybody's bios, she was named on the 2022 Forbes 50 over 50. Deborah, I hope I'm not outing you by saying you're over 50, but on the impact list, she's recognized for being, quote, a change maker who uses her empathy, insight, and savvy to make the world a better, more equitable place. So thank you for that. Welcome, Deborah. James Sandman is currently the Distinguished Lecturer and Senior Consultant to the Future of the Profession Initiative at University of Penn Law School. He's also had a very long and varied career in private practice with a big law firm, in government service, and as a public interest lawyer. He's president emeritus of the Legal Services Corporation, which is the largest funder of civil legal aid in the United States. He practiced law for some 30 years with Arnold and Porter in DC. He was the firm's managing partner, and he's also past president of the 110,000 member of the District of Columbia Bar. He's currently chair of the executive committee of the Board of Advisors of the Institute for the Advancement of the American Legal System. And there's many more positions that he's held, but one that I want to mention is that he was the past chair of the American Bar Association's task force of the legal needs arising out of the COVID-19 pandemic. He's a recipient of the American Lawyers Lifetime Achievement Award and named one of the 90 greatest Washington lawyers of the last 30 years. Okay, really terrific. So welcome, James. And Dan Rodriguez, he's currently the Harold Washington Professor at the Northwestern University Pritzker School of Law. He was the former dean there. He's been the dean at a number of other law schools. He's been sought after and taught at law schools around the country. In 2014, he was president of the Association of American Law School, and he served on the American Bar Association's Commission on the Future of Legal Services. Currently, he acts as an advisor to the ABA Center for Legal Innovation. He's a nationally known law teacher. His academic work and scholarship is in many areas: administrative law, local government law, and constitutional law. And I want to say also, he hosts a monthly podcast. This is a plug for Dan, called Planet Lex, which features conversations about the law and society, law and technology, and the future of legal education and practice. You know, we typically don't do such long introductions, but I was just so impressed with everybody's bio that I really had to tell more than just the basics. So I hope everybody is equally excited about tonight's conversation. So here's what we're going to do. Renee, we're going to start with you, and we're going to ask you to do about a 10-minute overview of some of the issues that you set forth in your book. After that, we're going to ask Ray to respond in about 5 minutes. And after that, I'm going to pose some questions to our panelists. The idea being we're going to try to have as robust a conversation as possible. As Teo said, please put your questions in the chat, and hopefully we'll be able to get to those during the course of the evening. So everybody, welcome. And Renee, we really look forward to the presentation of your terrific book.
Thank you so much. It's a real pleasure to be here with all of you. I appreciate so many of you taking time to think about this important topic. I really look forward to the conversation tonight. I have some slides I'm going to share, so let me do that to start. Okay, so I think my slides are up. But the way I thought I would begin my part of the presentation tonight is actually to share with you a very concrete example of what my book is aiming to solve. And to do so, I'm actually going to read a little bit of the book to you, just a couple of pages. Some of you may have already read this if you've seen the book, but I think it's a story worth reflecting on. And for those of you who haven't read the book yet, well, this is how it starts, and perhaps it will inspire you to read more. This is from the preface. "A priest is here to perform your last rites," a nurse whispered into my ear. What I really needed was a lawyer. At that moment, my temples pounded with the worst headache of my life. I struggled to adjust my arms and legs against tight nylon straps binding me to a metal gurney. My eyes squinted in the too bright light. Emergency room technicians and doctors spoke in code. The few bits I could understand terrified me. She's too young, University of Chicago graduate, a lawyer, so tragic. Neurosurgeon on standby. She has kids. She couldn't remember who's the president. There's space in the neuro ICU. Need to keep her at least a week. I was only 35 years old, the mother of 2 toddlers, on the brink of entering the tenure-track job market as a law professor, and blood was pooled in my brain. The prognosis, not good. My mind raced with questions about the imminent termination of my employment contract as a university lecturer, the recent conversations with my then spouse about divorce, the manufacturer whose drug made me faint and hit my head, the will I had not yet prepared to protect my children. I faced multiple problems that required legal help, and yet, even as a lawyer myself, I didn't know what to do. Most people, hopefully, will never find themselves as I did, bound to a gurney while declining a priest's reading of their last rites. But my plight of facing multiple unmet legal needs alone is not unique. Studies show that at any given time, the majority of households in the United States face 2 to 3 legal problems without a lawyer or other assistance. Most don't even recognize that their problems could be solved through the justice system or through legal tools. Now, more than a decade has passed since my full recovery from that grim day in the hospital back in February of 2010. Since that time, I spawned an award-winning venture to help law students find non-traditional paths to solve legal problems for those in need. I taught, researched, and wrote extensively about the lack of access to effective legal help and the possible solutions. This book is a journal of sorts, documenting what I learned along the way as I studied efforts to improve the delivery of legal services and tried to better understand why it's so challenging to do so. So that's a little bit about my story. And unfortunately, my story is a story that's repeated over and over again across this country. And I want to take a step back now and actually even situate the context of access to justice in the US worldwide. According to the Rule of Law Index in 2023, the United States ranked 26 out of 142 countries on access to justice and access to the rule of law, below the majority of other high-income countries. We're at the bottom 20% of countries in accessibility and affordability in the justice system, and 124 out of 142 in the absence of discrimination in our civil justice system. This is the problem that my book aims to solve. And part of why I wrote it, well, because I shared a very personal story with you right now, but there's more to why I was inspired to write this book at this time. And so let me pull the curtain back a bit and say just a few more words on why this book and why now. A number of years ago, the ABA called me a legal rebel because I had the idea to infuse law school curriculum with technology and innovation and created a law lab to do it. My work on advocating for the reform of legal ethics and the rules that govern the profession of law to expand access to justice is part of why I was selected to be a co-reporter for the Presidential Commission on the Future of Legal Services for the American Bar Association back in 2014 through 2016. And it's work like that that has informed what I now have put into a book. The first half of the book says a lot more about the problems we face, but I really care most about the solutions. And I don't know about you, but when it comes time for me to solve a problem, I need a plan, I need a blueprint, I need checklists, something to follow for concrete steps for action. And so let me share with you now the back half of my book, which is my blueprint for justice. And it's a checklist. It's a checklist that starts first with everyone we need to come together to solve the access to justice problems in this country. And it includes attorneys, advocacy groups, bar authorities, individuals, judges, law schools, members of the legal tech industry, legislators, and research centers. And what I've done in my checklist is try to categorize efforts that I've seen that were successful, or maybe not, and lessons we can learn from them throughout the US and around the world. And I really have at least two audiences that I hope this book speaks to. One is for anyone who is coming to this problem afresh and wants to know what's been done, where they can pick up the baton, if you will, and continue the race forward. An easy place to learn a lot quickly about what has been done and what needs to be done. But the other audience for this book is for those of us who have been immersed for years, some of us even decades, in trying to solve a problem that, frankly, in my research, I document goes back more than a century. And how I've found often in our silos, it's difficult to see all of the work around us. And so that's part of what my checklist is trying to do too. So let me close by just giving you a very high-level overview of what that blueprint looks like. I have several buckets or themes to my Blueprint for Justice checklist. And the first two, related to antitrust law and the First Amendment, go toward the way litigation can actually help us fuel the changes we need to increase access to legal help in this country. One of the most famous cases is actually from the 1970s, Bates v. Arizona State Bar, which struck down the advertising ban throughout the US. With the purpose to give people more information about how to get help to have their legal needs, their legal rights and entitlements enforced. Now, if we had more time, we could talk about whether or not that's been successful. And there's a whole chapter on that in the book. But even now, there are a number of cases that we should be watching. A case called Upsolve in New York that involves assistance for bankruptcy, a case that just settled in South Carolina brought by the NAACP for housing advocates challenging unauthorized practice of law rules. And there's another case pending in North Carolina, which leads to the next category, regulatory and legislative reform. You don't necessarily have to go to court to achieve that, right? There's a role for lawyers, for bar regulators and legislatures to step forward on a whole host of initiatives. And we might dive more deeply into those as we hear from the other experts who are speaking tonight and in the Q&A. I also call for innovation, but ethical innovation, infusing that into the professional conduct rules that govern the practice of law, and importantly, inspiring us to think about how we use technology, especially generative AI, and other technology tools to address access to justice issues. The rest of my blueprint focuses almost entirely on education, how we educate law students, how we educate practicing lawyers and judges, not only about technology tools, but also, importantly, cultural competency, entrepreneurship and innovation, bias training, leadership and development, and beyond. Another emphasis has to be education for the public. The public needs to know more about the legal system, how to use it, when they can solve a problem on their own, and how to evaluate a lawyer who might be able to help. Another important component to this, in my mind, is a national Bill of Rights for self-represented parties. And then I'll just say quickly that my blueprint also has a few ideas that I've categorized under the way forward. And these range from empowering engaged citizens to thinking about mental health and wellness for our lawyers and judges. Importantly, measuring any of the reforms that we engage in related to access to justice through national standards with empirical data and outcomes that we can share. And I conclude by borrowing from the title of an organizational psychologist whose work I admire, Adam Grant. In one of his books, he calls it Think Again. And it's something that is so important in this work that we often will set out aiming to solve a problem, the access to justice problem, and find that we are not looking at the impacts on the ground to make sure that it's actually addressed to focus on the people most in need. And that to me is one of the most important themes to every aspect of my blueprint for justice. So I think I will leave it for there now, but I look forward to hearing from the other experts whose work I have long been inspired by and admired and often rolled up my sleeves to work together with. And I look forward to the questions from the audience as well. Thank you so much.
You're muted, Ellen. Had to happen once. Glad you got it over with.
Oh, I can't believe it. Anyway, I want to thank you, Renee, so much. And I encourage everybody once again to read the book, because as she sets forth the elements of the blueprint, it's really quite remarkable and comprehensive. So with that, Ray, would you like to respond?
Sure. It's difficult to respond to that because it's as Jim Sandman sometimes says, you know, all of the above. Yes, we need these reforms. But I want to thank the Friedman Institute and the Science Center at Fordham for helping to host this. I grew up on Long Island, so Hofstra is close to my heart, and I was an undergraduate at Fordham, so Fordham's close to my heart. Professor Liebman, Professor Yarashevsky, Professor Green, who's not showing his face from Fordham. Thank you all, and thank you, Judith Black, for doing all the behind the scenes work. Thank you to our panelists, two of whom I actually interview in the book, Deborah and Jim. Dan, I didn't get a chance to interview you, but if you like what you hear today, as I'm sure you will, you'll read more in the book. I want to thank all of you for coming today. And also, I want to have a special shout out to the Hofstra Law Review, because some of the ideas in the book were in a piece that I developed at the beginning of the pandemic for Hofstra Law Review called Lessons from the Present, and they made it into the book, no doubt informed by the able editors of the Law Review. But mostly, I want to thank Renee. I did not read your book in advanced galleys or while I was writing my own, but I feel like we were in conversation, because there are so many areas where we come together. I focus a little bit more on the history of the profession. The first sort of half of the book is really focusing on, how we got to where we are on a number of different issues around, regulation of the bar, on limitations on the bar, on even the requirements of legal education. But that talks, I think, very much to your future-oriented perspective. But I wanted to focus on two things that really infuse your book. So, you gave the 30,000-foot overview. I want to go sort of 50,000 feet and maybe see the curve of the earth. But, you talk about two things that are critical and missing for lawyers and the legal profession generally, which is innovation and entrepreneurship. And you go so far as to recommend an amendment to the all-important comment 8 to Rule 1.1 of the rules with respect to keeping abreast of changes in technology. You broaden it to say, keeping abreast of innovation. You also make recommendation, alternative is to change the preamble. I really like you drawing from the preamble that this idea of innovation should be every lawyer's obligation to innovate, because we have an obligation to improve the legal system and access to justice. I really like that framework. I also agree that we need a little more of an entrepreneurial spirit. As an educator, I try to infuse both of those concepts into some of my classes, both innovation and entrepreneurship. But I think we have some challenges in the profession around both of those ideas. You know, historically, where it's a very small c conservative profession, we don't like change. I think both of us and Jim also note that virtually overnight, the profession did change in response to pandemic protocols, and that gives us perhaps some hope that maybe we can make some of the broader changes that we need. But we are a conservative bunch, and there's a bit of selection bias in people who go to law school, whether you're someone who's a fourth generation lawyer or first generation professional. Entering into the profession is a entree into presumably a decent job, a decently paying job, one that you can support your family. I started in legal services, in New York City in the early 90s, could barely afford my rent, but I had a job. But across the profession, people enter into the profession for sometimes conservative reasons. Again, small c conservative, even if you're going to make social change, as many of us did enter the profession to do that. So I just I believe that we need innovation. I wonder if you might think about how we can infuse the profession with that sense of innovation, with that sense of entrepreneurship. It's hard to teach a class and tell students, or to be a partner or a supervisor in a law firm, and tell your students or tell your supervisees be creative. It doesn't work that way. So that would be a question I would have. I mean, again, all of the above. I think we need regulatory reform, UPL reform. We need to open the delivery of services to people who need some form of legal assistance earlier in the process of their problem, not always by a lawyer, sometimes by a paraprofessional, perhaps by a bot. We need these reforms for sure to close the justice gap. But how can we infuse the profession with that sense of innovation and entrepreneurship that you embrace and embody, but we as lawyers don't always do so. So that would be my response. Just initial thoughts and reactions to a book that I really enjoyed, and thank you for having written it.
So thank you, Ray. This is already quite provocative. I often start a class with, how many lawyers does it take to change a light bulb? And the answer is change, right? And so I think you point out very succinctly a fundamental problem in the profession that Renee is trying to push forward. And many people in access to justice have tried to do, say, since I've been a lawyer, which is a lot of years, okay? So Deborah, I actually want to start with you with talking about, you've been the president of the ABA, and I want to talk about DEI first, the push toward making this profession more diverse. And what are as you see this now, we've made some progress, ever so slowly. What do you see as the major impediments?
Wow. Well, thank you for the opportunity to speak. And before I answer that question, I'm reminded, Renee, the book and that passage you read was really very, very powerful. And it reminded me of one of the things I tried to do actually wrote an op-ed was on medical legal partnerships. And I think that is something that we've seen can be effective. And we know that for a number of people, they may have medical issues, but then they have legal issues and the connection between the two. So that was very powerful. Ray, I also began my career as a legal services lawyer in the 80s. So maybe a decade before you. And if you think you weren't making any money then, it was even less. But as you say, it's a passion. So, I was thinking about how to answer this question because we talked a little bit about the diversity efforts. And for me, it's important to remember where we've come from. When I graduated from law school was in 1981. So someone out there will do the math and figure it all out. And in my class, so that meant I started law school in 1978 at the University of Miami, where 309 students. There were 9 African-American students, and I was one of 2 Black women. And if you look at the statistics now, that's not the case. There's certainly more students of color, more women. So let's first look at where we were and pause to recognize that there has been some progress made. It is true that the law is still probably one of the least diverse professions, and we have a retention problem with keeping women and keeping lawyers of color. One could ask, why is that? There are, I think, a number of reasons, but mostly for me, it boils down to, as we've just heard, the law is a conservative, small c profession. And even though there have been all of these efforts, whether they, I think you'd be hard pressed to find institutions that don't have diversity efforts. But were those diversity efforts, why were they created? How were they created? Were they mindful of things like unconscious bias? Was that ever addressed in these programs? Was there a real commitment to the programs? And how was that commitment measured? How was it defined? How was it built? Some would say that some of the barriers to success were never really resolved. You can put in a program, but if you're not, in a sense, building it from the ground up and revisiting it, you can't put it in place and then have a checkbox and say, okay, we have a diversity program. We have to keep evaluating and reevaluating what we're doing and what works and what doesn't work. And I think as we've heard from Ray and Jim talking about how we were able to pivot as a profession during the pandemic, then we wanted to go post-pandemic, because I assume we're post-pandemic now, go right back to the way we were practicing before. And that's not going to work. So now we're trying to figure out, how do we make progress in this post-pandemic world? And adding to that, I think, is how do we make progress when we see the attacks on DEI efforts? So we know that there are, within the ABA, of course, a number of programs and initiatives, but it goes back for me to the basics. How are we designing these programs? What is the goal of the programs? How are we measuring it? And are we taking stock as often as we need to?
So Dan, you've heard this. What do you think about efforts in law schools and what's working and what's not in DEI programs? Because I will ask Jim and Deborah and everybody else as well about the large law firms, which are still having the same problem they've always had in terms of making sure that people of color and women rise to the top. We haven't done that well in that arena. And we can talk to access to justice as well in more social justice worlds. But I want to start with the large law firm piece.
You're asking me about the large. I was hoping you'd ask about the large law school piece.
I know. I was going to start with
a little bit more in my bailiwick.
And then I was going to talk to Jim. Anyone can answer. Deborah,
okay, good.
go ahead. What's the
I'd
law
be anxious to listen to Jim's views about the large law firms, but
Okay.
I will speak to the law schools. First of all, noticing what Deborah said about the funnel, as it were. I think, my experience, I graduated from law school a few years later, but not many when she graduated. And I think we should take stock on the positive side about how far law schools and universities have gone. So, our law school and at Northwestern and the 199 other law schools, by and large, can point with great pride to the diversity in our classes by gender, by race and ethnicity. We understand that we're part of a funnel, though, that the longer one is in the profession, that progress slows down. And so we can't be complacent about it. So I think law schools are making some important efforts. I think the elephant in the room, of course, is the Supreme Court's decisions, affirmative action decisions recently, which pose some challenges. Some might say existential challenges to the strategies at the very least that law schools need to pursue. I'll give you a very concrete suggestion, and one that is an issue that's raging maybe a little bit within law schools more than certainly in the general public or the profession generally, is by and large one of the barriers to entry for diverse law students historically has been the unbelievable reliance by law schools on standardized tests, and in particular the LSAT, which we know, whatever the reasons and the origins for its biases, it yields, much like the bar exams do, some very what lawyers call disparate impact on performance. And so just recently, a number of folks, and I was certainly part of this group, was pushing the ABA Council Section on Legal Education to allow for the consideration of an alternative test called JD Next, which actually was developed at the University of Arizona, that the preliminary evidence and data revealed actually had as much probative value as the LSAT on the one hand, but on the other hand, didn't have the same racial effects. Now, truth be told, that much more data needs to be collected, and this is a work in progress, but there was an opportunity for a really important experiment until the ABA basically squashed it 2 weeks ago by basically saying, we're sort of happy with where we are with the LSAT, and we're just going to kick that can down the road. So we could sometimes be our own and worst enemies when there's some innovation and some possibilities to really make some progress. The relevant organizations need to get on board. So that's a very concrete answer to one element of the question you asked.
That's a good one. What about within the culture of the law schools themselves? Because oftentimes the cohorts of diverse students, do not feel as if they're getting enough support.
I think it's much of that is. I think that's a fair. I think we've talked about 30,000 feet observation. Although I think that we need to be granular, and I think certainly some law schools do a much better job, and the evidence suggests that what they're doing to work on issues of inclusion as well as diversity is having a positive effect. Other law schools have some progress that needs to be made. But I would say all the deans and associate deans that I've had the pleasure of working with believe this is an issue that deserves and merits their close attention. And we're all working on collective strategies that can help respond to, as you put it, the culture that can be very defeating. I'm a first generation Latino law student from the other side of the tracks in Southern California. There not a lot of us when I was at law school. It's a second Hispanic law professor at the University of California, Berkeley. So I've lived a lifetime in the profession of being part of on the cultural outs, as it were. And it's a real challenge. And I think it takes some extraordinary progress and courage also on the part of the students to persist in that in that world.
Jim, can you talk about law firms? And as I said, the problem is like rising to the top, right? Why is it that we're not doing a lot better in making sure that diverse lawyers rise to the top? And what can be done?
I think it's a failure of leadership. I think it's a failure of law firm leadership at the highest levels. I don't think law firm chairs and law firm managing partners have taken personal ownership of their responsibility for improving diversity, equity, and inclusion throughout the law firm, but particularly in the senior ranks. The underrepresentation of women and lawyers of color among equity partners in law firms and among leaders in law firms is appalling. I think this is a huge issue, not only for the profession, but for society. I think it undermines confidence in the legal system when people look at the people at the top of it and see nothing like the diversity of our society. It's a threat to the rule of law and respect for the system that we expect people to live by. I have noted in recent years the number of firms that have added chief DEI officers. I think that's a positive development, but I think it comes with potential downside, and that is the delegation of responsibility for improving diversity, equity, inclusion only to the chief DEI officer. They can't do it on their own. They are very unlikely to be represented on law firm compensation committees, on partner promotion committees. It's sort of a check the box exercise to have a chief DEI officer, but if that person doesn't have the power that the senior most leaders of the firm have to make change happen, they're not going to be able to succeed. I think every law firm chair, every law firm managing partner needs to make it a personal priority, a personal passion to increase diversity, equity, and inclusion in their law firms. Until they devote as much attention to that as they do to increasing profits per equity partner, we're not going to see progress.
You know, some years ago, when we made some progress, it was because the clients, the business clients, demanded, right, that there be people working on their cases who were people of color. What's happened to that initiative? Do we have any data on that? Does anyone know?
I don't know about data, but I can tell you what my personal observation has been. Too many clients have paid lip service to those initiatives. And what happens is when they don't follow through, it generates cynicism within the law firms about what they're trying to do. So they'll say, you need to report to us on what the demographics of your firm are. You need to report to us on what the demographics of the teams handling our matters is. And what partners making those reports tend to see is that they send them in to the client and they hear nothing in return, nothing. No matter how bad the numbers look. It just becomes a reporting exercise, but they don't see any follow through. There are a few exceptions. There are some U.S. corporations that have really followed through in terms of reducing the amount of work they give to firms that are underperforming on DEI, but they're the exceptions. I don't think that the clients have followed through on the commitments they have made so publicly.
Can I just add to that then?
Go ahead, sure, of course.
Yes. So I would just say, you know, people may be familiar with the ABA's diversity survey, and they have now launched a new version of it where clients can actually more easily and readily compare law firms and compare their efforts. And so I think, Jim, what we're seeing is that more clients, more in-house counsel are using those results and are having those conversations with their firms. And in some instances, I've talked to general counsel who say they sit down with their firms and say, okay, you're at this level, and this is where we need you to be, and how are you going to get there? So having that diversity tool and having the ability to readily compare their law firms, I think is another way that we can help push this conversation forward and not have it just be conversation, but really push forward and have action. And so I think, you know, the ABA's efforts there have helped in that way.
Renee or Ray, do you have any comments from the blueprint perspective of moving forward on this issue?
Well, I just want to emphasize, like, if I had my highlighter out and this was written, I would be all yellow over what Jim Sandman just said, which is really linking to why meaningful diversity, not just in terms of who is pipelining into our law schools, but all the way up to the top leadership positions of power in the profession, We need that to reflect the diversity of the public we serve. It matters to the rule of law, and it matters to the public confidence in the integrity of our justice system. And most important, it goes directly to whether or not someone who is facing a legal problem recognizes it as a problem that a member of the profession could actually help them solve. There's really good research, especially in other areas of professional life, for example, medicine, that shows individuals are more likely to go get the medical help they need if they can identify, if they see themselves in the person who is providing the service. And that's equally true for the legal profession. In my book, I talk about an empirical study I did with a colleague of mine at the University of Houston, where we looked at more than 1,000 lawyer websites just to see what image people see. Like, even setting aside the lack of diversity in the profession, there's enormous lack of diversity and even in how we hold ourselves out to the public. And our study showed that most of the websites were not at all diverse. And I think that that is troubling, both in terms of looking at who is holding positions of leadership and power and how we as a profession are holding ourselves out to the public. We need to be reflecting the diversity of the public we serve.
Yeah, and I think we also, you know, it takes leadership. Leadership has a significant role in this. You know, the late Judge Weinstein issued an order that he insisted on junior associates having primary roles in trials in his courtroom. You know, I think that the institutions of the profession, as we've been saying, need to diversify the ranks of leadership so that that sends a message to people coming through the system that that's an opportunity for them. I think that, you know, I had a conversation with some students last night about forming a professional identity and thinking about melding one's personal identity with their professional identity. And some of the students said, well, the professional identity that the profession has shaped is one that has been shaped by white men for centuries. You know, the professional identity, professionalism, and this, you know, I excavate some of this in the book, that the first, you know, the ABA's first rules of ethics were designed in many ways to keep the profession native born, wealthier, and serving wealthy clients. That's why we had restrictions on, you know, advertising. You know, Renee goes into her book extensively on the history of some of that, you know, those restrictions. But they really started with, you know, making sure that entrepreneurial, upstart lawyers from immigrant communities and communities of color would not be able to advertise, because if they could advertise, then they would get clients who worked in factories, who are injured by railroads, who are injured by trolleys, who are cheated out of money by banks. You know, like, we have to excavate what the, you know, the origins and the pillars of the profession for you know, their roots in a form of white supremacy. I mean, there's no other word for it or term for it. So I think we have to have an honest conversation about what some of the pillars of the profession, you know, how they were built and why they were built.
So, Jim, I want to ask you, let's say you're an associate at a firm who really cares about these issues. What can you do to keep the leadership accountable for underperforming with DEI? Are there ideas of how to move this forward other than to just tell leadership they need to change?
I wouldn't recommend that any one associate try to do it alone. I'd raise it more broadly as an institutional issue, right, and I would raise it as an issue among all associates, not just women associates, not just associates of color. I think that allies need to be enlisted in calling the attention of senior leadership to the problem, so that people see that this is a matter of concern to all associates. And I think that what I'd recommend is get statistics on your law firm. You can find them, even if the law firm doesn't issue them internally, about the number of women and lawyers of color who are partners or equity partners. Make your case. And it would be particularly effective if you can do it using market data to show ways in which your firm is not measuring up to others. That might be a low bar, since not many firms are doing particularly well, but to the extent that your firm is doing less well than others, I think it becomes a competitive issue. It becomes a recruiting issue. Make a business case for doing more. But I wouldn't be silent, and I wouldn't try to do it alone. I'd make it. Associates have market power. I guess that's and they need to realize that. You see it in the recurring salary increases. Law firms are concerned about the high rates of attrition among their associates, and their reflexive reaction to try to improve retention is to increase compensation. That's a reflection of the market power that associates have. I think they should exercise that market power in other ways, not just to get higher salaries, but to improve their professional experience through DEI as well.
Thank you. Before we move on, we have 3 topics to cover, and we could talk about this all night, I know. But before we move on to opening up the profession, just wondering if there should be more clearly articulated standards or rules about access to justice, an articulated obligation. We sort of have something in the ethics rules. It's not much. Anybody want to take that on? Would that help?
Who's the audience for these rules?
Well, that's a great question. We're going to open a lawyer. Should it be lawyers? Rules for lawyers as to how to open up. We're going to talk about opening up the profession. So maybe
my intuitive reaction to that is that is so opaque, and I'm not saying the way you frame it, but I think that my intuition is that the best one can say for that, it's opaque. The worst one can say for that, it's mere virtue signaling. We know from the data that simply exhortations to do more pro bono work are going to move the needle not hardly at all. So getting up on a high horse and saying lawyers should feel strong compunction to serve access to justice, and I know we're going to get into this topic, while they're standing at the barricades, as the comment just suggested in the chat, to stop access to the profession by non-lawyers, strikes me as risible.
Okay, anybody else want to comment on that before I turn to you, Dan, about opening up the profession? So anybody else? Okay, Dan, so let's talk about, as what I said was UPL. You could talk about Upsal, the Upsal decision, let people know what that is, but also talk about your ideas about opening up this profession.
Well, fortunately, thanks to the incredible work of Renee, who both in her own independent work is reflected in this book and elsewhere, and are also her incredible synthesis of what's been some really terrific work in the relatively recent years by folks who are doing empirical work, careful analysis, data. We know a lot. We don't know everything, but we know a lot. We know, of course, the scope and the magnitude of the access to justice crisis. We know, as I just alluded to, that it is not all that hopeful to think that the needle is going to move by some combination of more pro bono, although we're all in favor of that, more financial support for legal aid, although we're all in favor of that as well, or a so-called civil Gideon, which will never happen in any event, and not close the needle. So I think that my main lesson is read Renee's book, read the literature, read a lot of this information. But you raised one bit of litigation, so let me say a few things about that. Just so everyone understands, when you hear the term upsolve litigation, that is in reference to a company and actually an individual, Rohan Pahlavi, who helped organize this incredible lawsuit brought more than a year ago in New York on behalf of what am I searching for? A parish pastor. Sorry, I knew I'd get it. Who was an African-American pastor in New York who was looking to provide not legal representation, but simple legal advice to parishioners in order to essentially guide them toward dealing with significant issues. And New York's UPL restrictions seem to fall to impede that. So they brought a lawsuit under the First Amendment, arguing that the prohibition on providing this kind of legal advice was a content-specific restriction of the sort that the Supreme Court has long held is entitled to strict scrutiny and would run afoul of the First Amendment. There were a lot of skeptics. I was among them about the litigation strategy as being in the foreground. Be careful what you wish for. Be hard to imagine that the court would give credence to this. There were other skeptics who argued it's unrealistic and to expect that New York would invoke their UPL rules to in fact prohibit and stop this activity from taking place. Although incredibly enough, in oral argument, when New York was given the opportunity to say, "Oh, we would never bring a lawsuit against these individuals," that would have made the lawsuit go away, they didn't take the bait. And so the district court in New York reached a judgment that held yes in favor of the plaintiffs, and that struck this down as a violation of the First Amendment. And you can read the case. You don't need to have me describe it, about how it had followed a precedent. It's the beginning of a long journey. That case has been before the appellate court, Second Circuit, for quite some time. I want to hear from Renee. I actually wasn't aware of the settlement, and that she that's hot off the presses of the South Carolina case. But there's a North Carolina case, and there are probably many, maybe dozens of cases to come. So this issue will likely be litigated in courts in jurisdictions throughout the country, and it's way too soon to see what's likely to happen. But there could be a reckoning, as it were, with respect to a part of the problem, and only a part, which is to say the application of what in my view, anachronistic, unauthorized practice of law rules to stand in the way of the provision of simple legal advice. And let me just say one other word, and then I'll shut up about this. One of the things that's remarkable about this litigation is it brings together strange bedfellows. The South Carolina case was brought on behalf by the NAACP. I mix up my Carolinas, but I think I have that right. With the help of the Georgetown Law Center and let's call them folks from the left of the political spectrum. The North Carolina case was brought by the Institute for Justice, which, if you know anything about it, is a libertarian conservative group out of Washington, D.C. It is remarkable, I think, to witness the folks from both ends of the political spectrum who are coming together to challenge the hegemony, as it were, of the legal profession. I think that is a really interesting window into potential bipartisan efforts to really move the access to justice needle. And when you get IJ together with the NAACP, you better start worrying if you're the defendant, just given the consolidation of political and legal power.
Renee, you want to comment on the future? I mean, Dan set forth this political force.
Sure. Yeah, no. So just on that very point, it's part of why it has surprised me how long the litigation movement is still taking, because you do have this interesting convergence of interests where normally there would not be alignment. And it also surprises me that you don't see a legislative effort there too, right? Where you could actually maybe count votes from different sides that normally would be very opposed, but we are where we are. On the South Carolina case, yes, there's a bit of provisional approval of the program that was challenged there. The NAACP had brought forward a program that was allowing for very limited advice and advocacy in the context of people with housing needs. And so there has been a provisional approval of that program, although it had been challenged on the UPL grounds as well. So that's the update on that front.
Yeah.
I will just say I am surprised that we haven't seen more efforts using litigation tools. I do believe that Rohan, in crafting the strategy for the Upsolve case, it was very carefully done. It was very strategically done. And that's part of why I believe we have seen success there.
Yeah. One other quick footnote. Sorry, Ellen. Just to put one other little bit of flesh on the bones of the North Carolina case. That case, unlike the South Carolina case and the Upsolve case in New York, involves plaintiffs that are looking to also be paid. So there's some remuneration involved. And so just to be clear about it, you know, they're very sympathetic plaintiffs in the New York case, a pastor looking to give this advice for free. Same in South Carolina. Not so in North Carolina, where there's a judgment and there's also some technology involved. So you'll see these different species of cases with different kinds of plaintiffs entering the access to justice area from different parts of the ecosystem, I think in the coming litigation efforts.
So Jim,
if I can jump in, but I don't think that litigation is the only answer. And Renee, you go into, getting good data and, the remarkable work of Becky Sandifer and others on documenting the justice gap and teaching us why it is that folks, the extent of the size of the gap and why it is people don't access lawyers. The size is massive. B, the reasons are not always what we might think. It certainly includes cost, but oftentimes it is because people don't know they have a legal problem or don't know how to access a lawyer if they have them, if they do have a legal problem. So I think that there's a lot of work that needs to be done with social science research, and lawyers can work with their clients. When I was at the Urban Justice Center in New York City, we did a review of hundreds of civil court cases involving consumer debt, and found, really not a single defendant was represented by counsel. We presented that data to the city council and showed that, it wasn't, while many of the cases were concentrated in certain communities, the cases were scattered throughout the 5 boroughs, and that opened the eyes of the council members so much so that they wanted to fund legal services for this programming. So I think, the plural of anecdote is not data. We have the anecdotes. I think we need to continue to look at the data, to research the data, to make the case to policymakers. And Renee, you do a great job of laying out who the stakeholders are. But it's it's consumers, it's the bench, it's the private bar that wants to ensure that there is access to justice. It's law schools that want to expand opportunities for their students and then for their graduates. I think that there's, you used the term before, Renee, in talking about the litigation, that interest convergence. I think that there are lots of opportunities here for interest convergence. But we need the lawsuits for sure, but we also need to continue on the research. And it doesn't have to be, large national studies. Folks can do a study of housing court in a particular town, in a particular county, and make the case to local legislators of the impacts of eviction. Desmond's book, Evicted, we can tell these stories, but we also we need the data. For decades, the bar has won this fight by saying there's all this harm by if there's unauthorized practice of law. But rarely do they ever show it, right? That's the story of Bates. That's the story of other UPL cases. Where's the harm, lawyers? And it's very difficult to find. But the harm is not having access to justice, and we as a profession can do more to document it.
So we've talked about the need for access to justice for many years in the profession, right? Yet there's always such pushback, particularly in the ABA, which led, Jim, I think, to the formation. Well, it's a long story, but led to the group that you were part of, the Future of the Profession Initiative. So what's your sense of access to justice, opening up the profession through that leadership body, their suggestions?
Well, I think we're making progress in the last few years. 10 states now permit people who aren't lawyers to provide some kind of legal assistance that would otherwise have been considered the unauthorized practice of law, and the number is growing every year. 7 states have licensed paraprofessional programs that have pretty significant credentialing requirements. This is a concept that started in the state of Washington in 2012. When they created a position called limited license legal technician. The Supreme Court of Washington decided to sunset that program in 2020. They still permit people who were licensed previously to practice, but they're not taking any new applications. Other states have picked up on that model, but tried to learn from the Washington experience and do it better. Those states are Oregon, Utah, Arizona, Colorado, and Minnesota, and also New Hampshire. Minnesota and New Hampshire are doing this on a pilot basis. The problem with the Washington state program was that the credentialing requirements were so high that they had relatively few takers. Initially, the position required 3,000 hours of supervised practice, 3 different examinations. Look at the title they gave the position: limited license legal technician. I'm hard pressed to come up with a job title less likely to inspire confidence on the part of a consumer or less likely to attract any applicant for a job that sounds like that. It doesn't even fit on a business card. So the predictable happened. They ended up with fewer than 100 people over a number of years. That's not enough to move the needle. And they concluded that the costs of administering the program couldn't be justified by the relatively small number of participants. Other states that have adopted a licensed paraprofessional program have tried to lower the credentialing requirements, but many of them, most of them still require an exam. They still require some significant number of supervised practice hours. There's a new model that's emerged in the last few years that I'm more enthusiastic about. It's called the community justice worker model. It was pioneered in Alaska. The Alaska Supreme Court has grants waivers to people who, under the training and supervision of Alaska Legal Services, the only statewide legal aid program in Alaska, provide limited legal services to people. As long as a person is trained by Alaska Legal Services and supervised by Alaska Legal Services, and Alaska Legal Services files an application for a waiver on their behalf, they're good to go. And there is no limitation on the areas of practice in which they can provide service or the particular tasks that they can perform. So Alaska Legal Services has been using these people to do things like appeals of denials of SNAP benefits, Indian Child Welfare Act cases, get protection orders for victims of domestic violence. These people don't do this as a full-time job. They do it as volunteers with or potentially as employees of Alaska Legal Services. But most of them are embedded in community organizations where they provide some form of legal services in addition to their usual jobs. So for example, a social worker in a domestic violence shelter could be trained and supervised by Alaska Legal Services to go to court and get protection orders for people in the shelter. It's sort of bite-sized training for bite-sized problems. And it doesn't require a person to give up their day job to become a community justice worker. That model is like what the South Carolina Supreme Court recently authorized for tenant advocates under the auspices of the NAACP, and Delaware has a similar program for people providing assistance in eviction cases. What's interesting to me is when you look at the numbers of participants that these different models draw, In the states that have the credentialed, licensed paraprofessional programs that have followed but cut back on the Washington credential requirements, you don't see large numbers of people. You see numbers that are currently ranging between about 25 and 60 people for a whole state. That's not going to make a dent in the justice gap. In Alaska, by contrast, with their community justice worker program, they've already got 400 people either trained or in the training process. This in a state that has a total population of 750,000 people. If you're going to solve the access to justice problem, you need solutions at scale, at a scale proportional to the magnitude of the problem. 25 licensed paraprofessionals or 60 or 100 is not going to do it. But if you can mobilize hundreds and thousands of people using the community justice worker model, there you might make a difference. The bar is usually opposed to programs like this when they're first suggested, and they always frame their opposition in terms of protecting the public. We need to protect the public from people who might be incompetent or unethical. My response is, compared to what? We've created a system where if you can't afford to hire a lawyer, your alternative is you're on your own. We've decreed that you would be better off on your own trying to navigate this crazily complex, opaque system. Do it by yourself. Because God forbid, if you were to try to use one of these trained, licensed, regulated paraprofessionals, you might be harmed. Give me a break. Some competent help is better than no help at all. And when we stand up and deny people alternative competent help simply because those people are not members of the bar, we are harming the public. My view is that the current regulatory system itself does harm by denying people who can't afford a lawyer access to any kind of help at all. That is not protecting the public. It's upside down.
That was really well done. Thank you. I mean, years ago in New York, when we were arguing about these kinds of programs, even Judge Lippman, who's really known as an access to justice person, argued vehemently that all we would do would create a two-tier system of justice that would impact particularly indigent people of color. And so it's sort of like DEI being used against itself, right? And that argument still seems to have force among lawyers. And it's not, we already have it. I don't know if we have two-tier, we have a one-tier, which is rich people get lawyers and yes, everybody else doesn't. And
two tiers would be a step up.
Right. Deborah, I'm wondering, as you look back on your tenure at the ABA, the extent to which you felt like you could make progress in this kind of an area.
Yeah, so one of the things when you're ABA president, you recognize that you're limited in what you can say and in some ways in what you can do by ABA policy. So as has been, I think, if not directly indicated, certainly indirectly, you know, this whole issue is one where there is not consensus within the ABA, where there are those who, on the one hand, in the Innovation Center, are looking at ways in which we can provide access, but there are those other lawyers who, as Jim has articulated, talk about protecting the public and having those kinds of debates. But what we have seen is that there is certainly a support of providing access to the legal system. Certainly our support of the Legal Services Corporation, I think, every year lobbying on behalf of LSC and using that as a way to try and gain more access is one thing that we've done. And we will obviously continue push for that. But it is not. There are a lot of great minds in the ABA that don't necessarily always agree. But where we can agree, and when we looked at the surveys, and I know that many of you know this, but it's worth repeating, we do know that when the ABA does surveys, civic surveys, and surveying the public, in 2022, that survey, 52% of respondents said that they thought that there was bias built into the justice system. And if you break that down among young people aged 18 to 36, 63% believe that there's bias built into the system. And 48% of whites, 54% of Hispanics, and 75% of Black respondents believe that. So we know that part of that problem is that you don't see people who look like you in the justice system. You don't have access to justice, and it makes you feel that there's bias built into the system. So what we can do in the ABA, what we try to do, is to make sure that we are addressing those needs in a variety of ways, including having the debates about allowing non-lawyers to have limited practice. And I think you're seeing a shift. It's certainly not maybe as fast as some would like, but I think you're seeing a shift there.
Dan, you want to?
So I want to begin by saying I have enormous admiration for Deborah and her work on the ABA, and indeed have enormous admiration for a number of presidents that I've had the opportunity to know over the years, including William Hubbard, who started us on the pathway to the Commission on the Future of Legal Services. And I certainly also appreciate, to the extent I know about it, the ways in which Deborah is in the ABA is quite constrained, and appropriately so with respect to ABA policies. So that's all of a wind-up to say I absolutely think that the ABA is a shameful and terrible impediment to the topics that we're talking about. I don't want to make, to society, but to the opportunities available to paraprofessionals and other modalities of the sort that Renee describes that. I appreciate and respect what Deborah's saying about there's conversation. I had the privilege to not only be a member of, but to chair the Center for Innovation in the ABA for a number of years. It is not a voice for substantial change. And you don't have to take my word for it. Let me read you a resolution. I promise you it's very short, that the ABA House of Delegates passed as policy, Resolution 115. I'll read you the key parts. It begins by saying, and just let this sink in, resolved that the American Bar Association encourages U.S. jurisdictions to consider regulatory innovations that have the potential to improve the accessibility, affordability, and quality of legal services. Pretty good so far, while also ensuring necessary and appropriate protections that best serve clients and the public. So you can see, apropos of Jim's comment, here's the rest. I'll read this without commentary, including the provision of legal counsel as a matter of right and at government expense for children facing essential civil legal matters and for low-income individuals in adversarial proceedings where basic human needs or a loss of physical liberty are at stake. Later in the same resolution, it also goes on to say, further resolved that nothing in this resolution should be construed as recommending any changes to any of the ABA model rules of professional conduct, including Rule 5.4, as they relate to non-ownership of law firms, the unauthorized practice of law, and other subjects. Renee takes a deep dive into this issue in her book, and I won't. So just consider what that resolution does. It starts out by saying we're in favor of innovation, but make sure that you only lawyers represent low-income folks in these particular settings, and don't even breathe a word about Section 5.4, which, as Deborah knows, 2 years later, they passed another resolution indicating, and we really, really mean it, don't even think about rule changes in 5.4. How can you expect the ABA to be an institution of supportive innovation when you have absurdities of that, the likes of which, I can barely describe.
So Renee,
I never said that the ABA made sense in every respect. But what I do say, having chaired the House of Delegates and having having served as president, is that at least in the ABA, we are grappling with it, and there are different sections and different parts of the ABA that are doing its part and doing their part to make sure that we are advocating for not only the funding, but also the kinds of programs that will provide access. So while we may have policy in one area, there are certain sections and divisions and forums that are going about doing the work and promoting and working with local bar associations, state and local bars, and partnering with them to try in some way to bridge this justice gap. So it's a complicated organization.
Well, the ABA is an important voice, right? It's a powerful voice, but it's not the only voice, right? So, Renee, do you want to talk about a path? We're going to move into use of technology because that may be an area for innovation that could have a significant impact upon access to justice. But do you want to just stay with the UPL issue for a moment and maybe address Dan's point on 5.4? Because I'm not sure everybody knows 5.4.
Sure. Yeah. So I'll go back and just identify, I think I'll talk about 5.4, but let me also just wrap up the comments or chime in on the comments about the tension for an organization like the ABA, which we can identify many ways in which the ABA is in fact part of the problem and has perpetuated the problem. And yet it's also been led by people who care very much about solving the problem, like Deborah, like William Hubbard and Judy Perry Martinez as well. And so I don't think the ABA is alone in this tension in the legal profession, right? I can have the same conversation with you if we want to look at state bar associations, if we want to look at legal education. As a professor, I'm mindful I need to look at my own home too, right? And there was even a comment, I think, in the chat asking, is legal education part of the problem? Yes, we are. And we need to figure out how we are also part of the solution. And so I would just say that the ABA is not alone. It's just one example of this tension that happens over and over in every aspect of the legal profession. I also wanted to say earlier, another sort of example of that is the fact that so I totally agree, litigation is not the best path forward for solving these problems. And yet it's a tool that we resort to using. And think about how strange that is, that we have to litigate against the legal profession that is regulating the practice of law in order to address these issues. So all of these are examples of this tension. And I wanted to make sure that we weren't singling out the ABA, but recognizing that it's just one example that we see over and over again in our profession. And it's something that really future members of the profession, I think, have to grapple with. Now, on 5.4, I will just say this. So that is a rule of professional conduct that prohibits outside ownership and investment. So money from non-lawyers investing in the business practice. It's the sort of thing that in any other industry, you welcome outside investment because that's what often will fuel your ability to be innovative or try creative new solutions or invest in a new technology and that sort of thing. We do have a couple of jurisdictions. DC has always had sort of a different way of handling 5.4, but most radically and most recently, Arizona got rid of Rule 5.4 entirely and is allowing for what is known as alternative business structures. This is a model that was borrowed from England and Wales after the passage of the Legal Services Act in 2007 that allowed for this structure called alternative business structures, although it's not so alternative anymore. To Jim's point, I think we could probably do a lot better naming a lot of things, not just legal limited licensed legal technicians, but also alternative business structures. But for whatever reason, Arizona has continued to use that terminology in what's happening there. And so far, the sky hasn't fallen. And in fact, there are a whole range of different kinds of providers of legal services who have availed themselves of the new business model, if you will, that they can adopt in Arizona. So you have providers like LegalZoom. Most people have heard of LegalZoom. They have an ABS in Arizona, but you also have small groups. There's a group of nuns, for example, who have formed one. So Arizona is a place to watch what happens next. And I think it's also a signal that many of the concerns that have been articulated about the risks to the public, for example, or the risk to professionalism if we allowed for a reform of 5.4, or if we got rid of it entirely, are no longer really going to be viable given the path that Arizona is on. And so that's certainly something to watch.
Great. Does anyone want to comment on that before we move to technology?
I just want to comment actually to build on something that Ray said before. I mean, just to make an obvious point, 5.4 is not a law. It's a model rule that was proposed by the ABA. So state bars, of course, are perfectly within their authority to disregard it. It is also possible that we could get action from Congress. Now, you know, I think that my own view is that's far more likely than seeing a congressional statute that deals with paraprofessionals practicing legal services. So if despite the ABA's efforts to basically say don't even talk about changing one iota of 5.4, it could be that down the road there could be a combination of antitrust lawsuits that could be part of it, but maybe even more commonly congressional legislation that would sort of wipe out the ABA's 5.4 and allow this to be developed. Because with all due respect to Arizona, it'd be really interesting to watch what happens there. But Arizona ain't California and New York. And so it really would take some big state. Again, I mean, it just is what it's reality. It takes some really big states to innovate, to test. I think the question that we all have, which is, would you move the needle of access to justice with the repeal of 5.4? I think we don't have information about that to be confident.
Okay, so what about legal technology? That's our next major issue. We started by talking about lawyers not being innovative, which we know they're not. As a group. But on the other hand, here we are faced with fundamental changes, right, in the practice of law with the advent of legal technology. So to what extent do we, Renee, maybe you want to start there because you've talked about that in your book and we haven't explored that area yet.
Sure. So, you know, I'm curious to hear what others have to say about it as well. But the point that I raised in the book is that we certainly have technology tools. Some are imperfect. I share stories about tools that worked and haven't. But also we can't ignore the reality that technology, like, you know, ChatGPT and generative AI is going to be used whether we want it to or not. And so there's sort of two things that I'm concerned with. One is how do we make sure that lawyers are involved in the creation of tools that are going to be used to provide legal help? And, you know, to make sure that, you know, if we're talking about something like generative AI, that it's a data set that can be relied upon, right? And that's where I'm thinking about concerns related to individuals who are coming to use those tools who might not have the training to recognize, oh yeah, that's a hallucination, or that's something that's made up, that's not reliable, and this is something that I can rely on. But then I also think a lot about how lawyers can be providing more affordable, better legal services by using these tools. And so there's an obligation, I think. So right now, the model rule, and it's been adopted by most states, related to lawyer competence, does include in the comments an obligation that a lawyer has a duty to keep abreast of technology changes in their law practice. I would take it one step further than that, and not just to keep up with what's going on, but really to actively engage in both paths. How can one improve the services they're providing as a lawyer? And what are the tools that the public can use to solve legal problems, or more importantly, maybe even prevent them before they happen through technology tools? And can lawyers be involved in the back end of that in order to make sure that they are
So Dan, do you have a vision of how AI and generative AI and just legal technology in general can move forward access to justice?
Let me start with a sort of a glib comment, which is the more I study it, I realize the less I know. But I really mean that. I mean, so no, I do not have a vision of how it should develop. I do truly believe, and I think Renee said it beautifully, that it's incumbent upon us to embrace technological innovation, which is not the same thing as embracing every technology that comes down the pike. We have an obligation, let's start with law schools, to help our students understand the capacities and the risks associated with many technologies, including but not limited to generative AI. We've had our own debates within the school about what to do with respect to pedagogy and curriculum and all of those things. I sometimes fear, though, that the conversations tend to be very insular and kind of inside baseball, where what we really need in legal education is to be connected with the profession, to have this comprehensive, coherent discussion that will give us the benefit of wisdom of the crowds. It will include, but not be limited to, folks who have true depth and breadth of expertise in technology, but it needs to include those folks as well. And I was struck by a phrase that Renee just used, which is back end. I think that's really important. It's obviously we want lawyers to be really not only in the room where it happens, but also supervising a lot of these developments. At the same time, since we're on the subject of access to justice, I think I do have a vision or envision a world in which there will be some ability of ordinary consumers to use technology to cut out the middle person to some degree under appropriate regulation and under appropriate controls. My confidence in that being a vision of the future rests squarely on how much lawyers are involved in the back end in developing those technologies. And I fear that in the first wave, a number of years ago, when everybody was being an entrepreneur and there were startups and folks were pitching this and that technology, you seldom saw them interface significantly with experienced lawyers, much less clients with particular problems. So if all of the folks are in the proverbial rooms to discuss those, and to really take deep dives into those matters, then I think we can be confident with appropriate regulation, appropriate risk assignments, appropriate use of what's sometimes called the precautionary principle to really yield some tremendous benefits of the sort that we're already starting to see in the use of generative AI in the medical profession and in other parts of the economy. It's not coming; it's here already.
Right.
I think that both Renee and I, in our respective works, talk about the research, the theories of Clayton Christensen, who sort of coined the term disruptive innovation, but we have to understand even his analysis. He describes disruptive innovation and sustaining innovation. To date, most of the technology, and Dan, you sort of talked a little bit about this, most of the technology, the recent technologies, have been sustaining technologies, sustaining innovations, because they're making some lawyers' jobs easier. And who are those lawyers? It's that one tier of the profession that we've been talking about. And in fact, there's a greater threat that the new technologies are going to deepen and widen the access to justice crisis and not solve it, unless we take Christensen's theories to heart, who said that true disruptive innovation happens on the low end of the market. And that is not something that the legal profession has realized in the onset of new innovations, new technologies. We have not really directed it at the low end of the market because people are it's all B2B right now. It's business to business technologies. It's trying to make law firms more efficient so that they can, serve more clients, bill more hours, and not necessarily using it to deliver services to the low end of the market. So I think that we need to experiment and explore ways that generative AI and other technologies can improve access to justice. Jim and I are writing a chapter on a couple of examples for a book for the ABA on AI and access to justice. But we also have to realize what happens with technology in the legal profession is at first it's a threat and then it's the standard of care. No one can walk into court today and say, Your Honor, I'm sorry, I didn't realize that that case was overturned because the pocket part of Shepard's was still on the librarian's cart at the law library, and I missed that the case was overturned. To say that you were using, the books, the Shepard's books, to do shepherdizing would get you laughed out of court, right? So the technology becomes the standard of care. We also have to remember, when other technologies were introduced to the practice of law, things like the telephone and the typewriter in the late 1800s, that lawyers chased them out of the office, right? Saying that, well, no client would ever want to talk to a lawyer over the phone. No client would ever want to get a typewritten letter because it breaks the bond between the lawyer and the client. They also said they didn't want women in the law firms too, even as secretaries. So we can have a whole nother discussion there. But, eventually there's adoption and it becomes the standard of care. And Dean Perlman from Suffolk has a new paper that's making this point right there. I do think that there are ways with a lawyer in the loop that we can improve the provision of legal assistance and guidance through things like chatbots, through things like document assembly tools. In the vast majority of the cases that a lot of low-income people find themselves in, consumer debt cases, housing cases, to name just two right off the top.
So Jim, I'm going to turn to you in a minute to talk about the work that you and Ray are doing. But before I do, I just want to tell people, please put your questions in the chat. We have 12, 13 minutes left, and we're happy to entertain questions. So Jim, do you want to amplify what Ray's talking about in terms of the way in which technology can really help low-income people?
I can't imagine a solution to the access to justice crisis at scale that doesn't involve technology. What technology allows you to do is to disseminate information at scale. The access to justice problem is in significant part a lack of information getting to people who need it. And I think technology can help a lot there. I do think I'm an optimist about the prospects for generative AI making a difference here. I understand its limitations right now, but I agree with what Dan said. You need lawyers. I don't know whether he said in the background, but lawyers need to be actively managing the development of the generative AI, particularly if it's going to be direct to consumer generative AI as opposed to generative AI that is used only by lawyers themselves. But let me give you an example. Ray mentioned document assembly applications. These have been around for some time. They work like TurboTax. They allow a person to complete a plain language interview using a program that then takes the answers to the interview questions and populates a court-approved form with them. That all goes on in the background in the way TurboTax works. You go through a TurboTax interview, and TurboTax figures out on what line of what IRS form to put the information that you provided in response to the interview questions. You can do the same thing with court forms. That technology has not scaled sufficiently to this point to make a significant difference in narrowing the justice gap. And the reason is because of our system of federalism. Most legal issues that affect individual people are matters of state law, not federal. If you create a document assembly app, it's good for one state and one kind of case, and sometimes not even that good. If you're in a state that doesn't have a unified court system, you can have different forms in use in every county in the state, and sometimes different forms in use in every different courtroom in the courthouse. I think generative AI offers the potential to streamline and expedite what up until now has been a very labor-intensive process in generating document assembly applications, and that could be a game changer. Ray and I are familiar with a program in New York that provides housing advice. What it does is, instead of just drawing generally on the internet, it draws on curated resources overseen by lawyers. And what it's searching to provide information is information that has a high level of, you can have a high level of confidence that it's accurate because lawyers developed it. It's not just drawing at random from the internet. So I think there are use cases out there already that show the potential. One final thing I'd look at, there are some big law firms and some corporate legal departments that are going all in on generative AI. And they're doing it notwithstanding what everybody says are the limitations of generative AI. I think we should look at how they're using it and see what lessons might be drawn from that on how it could be applied to the legal problems of individuals and low-income people. I think they are likely coming up with creative, competent, ethical uses of generative AI that have lessons for application to the justice gap.
Is anybody doing that now? What's the role of law schools in doing that? Jim, is anyone doing that?
In doing what exactly? Oh, sorry.
Looking at exactly what law firms are doing. If that's really true, that they're ahead of the game, right? In using generative AI. What's the role of law schools in working with those firms to try to understand that? What is their role?
The law schools that I'm familiar with that are doing it are either doing it on their own in labs that they've created, or they're doing it with the access to justice community. I'm not aware of anybody who's partnering with the law firm and the corporate legal departments. Look at them too, partnering with them to see what their uses are and what lessons could be drawn from their experiences that could be applied in the access to justice context. I think we make a big mistake in thinking that the world of big law and corporate law is something different from the world of access to justice. There are lessons from one world that can be applied to the other.
I also think that there is some work being done in some of the forward-thinking firms, but there are off-the-shelf products and from companies. Joseph is one. Microsoft is doing some work that they are really designing these expert systems, and we need to partner with them. And the program that Jim talked about with the New York chatbot is a partnership with Joseph, with one of these companies. And Renee, I think you highlighted in your book, but there are these off-the-shelf tools that are low code, no code tools that our students can use with some guidance. The Center for Computer Assisted Legal Information, Cali, they've been using the A2J author, which runs Neotologic in the background. That's the document assembly stuff that Jim has been talking about. There are some off-the-shelf products that can be used that do not require any kind of real coding expertise.
So Dan, my question's directed to you, just with the role of law schools in training students and training faculty, frankly, as well.
Well, that's a big challenge.
I know.
Absolutely, that's critical. When I was dean, I had the opportunity to visit with a number of alums and also law firms in the UK, and I was really struck by how advanced. Some of you have heard the expression "skunk works," sort of within an organization, and I found a lot of these leading UK law firms, Magic Circle firms, we're actually developing these sort of skunk works of sorts, sense, so these entrepreneurial groups within the structure of the law firms. Jim would know better than I would whether the incentives that exist to do that in the UK are different than the United States. And of course, global law firms could do that in various places. But to your question exactly, I also found that a number of the law schools there in the UK were just further along than, in my experience, law schools in the US were doing that, with some conspicuous exceptions. And I always came back with copious notes and long to-do lists about trying to encourage some of that work in our law schools. But we have a long way to go to really bridging those gaps that exist. The initiative that Penn is doing with under Jim's leadership is an example, and I could mention many others. That you mentioned Dean Perlman, and what Andy's doing at Suffolk is tremendous. What Renee pioneered at Michigan State. By the way, she's got a wonderful chapter in the book that is a really interesting tour through what law schools are doing. So it's easy for us to say, not enough. We're part of the problem. We're Luddites, but there have been some real advances and some real tremendous that a number of folks on this call have been part of, that I think should be acknowledged and incentivized to continue.
So I agree. So Renee, we have 5 minutes. Well, I'm going to give you 4 minutes. You're going to get the last 4 minutes, given the fact we started with your book and we're highlighting your book today. Next time we're going to highlight Ray's book. You can comment on anything you like in the last 4 minutes.
Oh, well, first I just want to thank all of you for spending this time talking about these issues through the lens of my book. It means a lot, again, as I said at the outset, because I have admired your work, worked alongside many of you for a long time. On this technology piece and its place in law schools, it's exactly right that some law schools are doing extraordinary things, but even in the ones that are, at least my experience has been that certain law students self-select into that path, and they think, oh, I have a particular skill set, so this fits for me. And the reality is, moving forward, every lawyer needs to understand the basics of legal technology tools. It needs to be a holistic part of our curriculum, both because lawyers will be using them in their law practice, but importantly, because we need to understand how they are being used broadly in the world around us. And so I would like to see it not just an option at some schools, but something that is more holistically adopted across the law school curriculum. I do think that that's something that perhaps is a recommendation that an organization like the ABA could be helpful on in these issues, right? I'm a big fan of using resources like the ABA or a bar association to convene people, to move them forward in ways that maybe are less controversial than the 5.4. And to me, I think this is a place where we could see real traction and real meaning. The last thing I will just say, since you brought up Joseph, for people who aren't familiar, it's a company that was founded in part, one of the co-founders was a lawyer named Sam Flynn. And the reason why he was inspired to do it, so basically they have created all kinds of tools for interactive chat bots and the like, partnering with law firms to...
You're frozen a bit. Maybe he'll come back. You're frozen.
Am I still?
We can't hear you.
Oh.
Go ahead, try again.
Okay. Sorry.
No, go ahead, try again.
Okay.
Yes.
Okay. Hopefully I can get through. So Sam Flynn was inspired to create his company because of a problem he observed in Australia. People's fare cards for their trams, if they didn't use them properly, they were being subjected to on-the-spot fines. And you can read more about it in the book. It's a story that I open with. But he felt that was a problem, and so did 60,000 people in Melbourne who downloaded his app, that informed them about their legal rights and entitlements. No advertising was involved, but he was solving a real problem for people that they had in their day-to-day life, and he was giving them a legal tool to help themselves. And that's exactly what we need to see more of.
Well, that's great. A perfect ending. I just want to, this has been a terrific conversation. Thank you all so much. This is really wonderful. I hopefully everybody stayed on, so that means a lot. And I want to thank Teo, but particularly our guests who've come forward to talk about the future. You know, there's some hope here. I think it's hopeful. Yeah, as Deborah said in the beginning, we're making progress ever so slowly. So even hopefully that light bulb will get changed by lawyers and not lawyers in the future. So thank you all so much. It's the bewitching hour of 8 o'clock. This is perfect. Thank you all.
Thanks, everybody. Have a great
Bye.
night.
Thanks, Ellen.
Thank
Thanks
you.
all.
Everybody.